So good afternoon, everyone, and welcome to this particular webinar, which is jointly organized by Faculty of Law, Marwadi University, and Weera Center for Peace, Justice, and International Law. This particular webinar, me and Umar are planning for quite a long time, and the biggest problem, to be very honest, we were facing was to get the right kind of people to talk about it. And we are very fortunate that we managed to contact Priyanka and Gopakumar sir for who are the right person who can talk about this particular topic, and that is to say international health law, and how it has faced the current pandemic, and what are the effects of international law that we can visibly see on the current pandemic situation. So without wasting much time, I welcome Priyanka Dahiya and Gopakumar sir for this particular webinar. I also welcome Umar and all the other participants for this particular webinar. I'm sure we will have more attendees coming in as the webinar progresses. So I would request Mohammad Umar, who is an assistant professor at Bennett University School of Law, to introduce this particular webinar. And then we will go ahead with our guest speakers. Please, Umar sir.
Thank you so much, Professor Dave, and it is indeed a privilege to host this seminar or webinar, as if it were, on such an important topic. Now, let me just briefly tell you about the working of the Weera Mantri Center. Well, Weera Mantri Center for Peace, Justice, and International Law is the tribute to the life and work of Professor Judge late Christopher Weera Mantri, and the kind of work that he did, especially in the areas of environment and disarmament. And of course, as we know that he is known, his legacy is known to be one of the most important voices in the areas of human rights advocacy as well. So our main aim is to promote knowledge with value and order with justice. And our main areas in which we intend to work in future in due course of time are the areas of nuclear disarmament, general human rights advocacy, and third world concerns and environment. So these are the areas that the center seeks to explore further. And we have launched an international journal, and also we have the essay writing competition, that is also the international essay writing competition. And the theme of that essay writing competition is the state's responses to the COVID crisis and the kind of inequalities that are inherent in those responses. And perhaps I think that is the most important background in the kind of discussion that we are having today, where we are discussing how the international health law has been extremely critical in managing the COVID crisis worldwide today, and it has its own ups and downs. WHO has been doing extremely critical work of ensuring that that it is properly monitored, essential health services are ensured. I was reading recently that we have the COVAX facility available now, in which around 165 countries have already committed that they would be, not only assisting themselves, ensuring the access to the medicine of COVID-19 to their own population, but also to other populations. Most importantly, many of the G20 countries are also the part of that facility. So these are some of the very, very encouraging signs coming from the organizations like WHO. And I am sure that all of this also has still some issues which needs to be discussed and pondered upon. So therefore, I think the kind of panel that we have today, Ms. Priyanka Dahiya from WHO, will be listening to the first-hand perspectives from Ms. Priyanka and Mr. Gopakumar from the Third World Network, who would be touching upon mainly and broadly on the equity issues in the functioning and the applicability of the international health regulations. So I would, I think, finish over here, and without wasting any further time, I leave the floor open to Ms. Priyanka Dahiya to take forward the discussion.
Thank you, Umar, for your views. Now, before I request Priyanka Dahiya to, give her views, let me introduce her to all the audience. Priyanka is a tenured policy and advocacy specialist with 12 years of experience in public health and human rights in key organizations like WHO, Global Health Strategies, I Pro Bono, Public Health Foundation of India, Campaign for Tobacco-Free Kids, and International Criminal Court. She is a law graduate from Nalsar Law University with an LLM from Northwestern School of Law, USA. She has worked in support offices in countries across the world, including Switzerland, Bangladesh, Pakistan, USA, UK, China, Mexico, Nepal, and India. She has been instrumental in global and national level policy and advocacy issues to build capacity in various public health aspects, including tobacco control, immunization, disability, and nutrition. She has worked as a technical officer for tobacco control at WHO Geneva, where she was the lead lawyer on WHO report on global global tobacco epidemic. Apart from advising on policy matters, she has been actively involved in research and strategy formulation for addressing key health policy issues. Priyanka, without wasting much time, I would request you to share your views uh, with the audience. Please, Priyanka.
Thank you so much, Professor Dave, and thank you so much, Professor Omar. It's a pleasure to be part of this webinar. I'm happy to be invited by Marwadi University. And it's always fun, and I really like interacting with students, even though I've not, been a professor, but taken a few lectures. So it's always fun to interact with students. I'm very happy to be here. Like Professor Dave said, I've been working in public health policy for now over 12 years. I am consulting with WHO right now also on their public health and law related treaties and mostly on non-communicable diseases. And like Omar said that, the topic today is very relevant, very important. And we all have been thinking, sleeping, talking COVID, I think, since March, as soon as we all heard it and it came to India. And I think that discussion hasn't really stopped. And we discuss everything from treatment to inequities, even if we don't use these terminologies. What's happening in China? Was China wrong? What's happening in Italy? When will things come better in India? But, all this discussion has a few foundations, and one foundation is global health law. If countries were prepared and if they were looking and complying and, seeing the global health law perspective completely and holistically, the response would be faster and much better. That's why my discussion and my viewpoints, I have a short presentation as well, which I'll share the slides right away, is more on, why do we need global health law? Because if we don't have global health law, we really have no foundation to treat, to respond, and to prevent in future these pandemics. So without wasting any time, I'm going to share my screen and start the presentation. Just wanted to understand from you, Omar and Professor Dave, if can students ask me questions or will they type in the chat?
We have a separate question and answer tab if you see in the bottom. So whenever they will ask any question, it will show up over there at the question and answer tab.
All right, but is it possible if I can ask something right now, or?
Yeah, if you want to interact with them, I can enable the chat with all the participants.
That would be great. As in, I don't need to utilize too much time, but it'll be great. I just wanted to understand what students have, in their mind when I ask.
Yeah, now participants, you can also write on the chat option available.
Great. Thank you so much.
Yes.
So let's start what global health law is, what has the history been, how it is used by countries, and how we can use global health law as a response to COVID-19. So going forward, I'm going to discuss nature and scope of global health law, the standards of World Health Organization when we're talking about health and law, and in international and global perspective, we have to talk about WHO. Health as a human right. Health is a very, very important human right. As important as a fundamental right. And if we do not equate health as a human right, there is no point of having a global health law, because it will never be equitable. And how does global health law respond to COVID-19? So just quickly, I wanted to understand, and students can type in the chat, what do you think, according to you, is the main cause of death globally? Is it tuberculosis? Is it COVID-19, road accidents, cardiovascular diseases, heart diseases, respiratory diseases, COPD? We'll go through it later, but it'll be good to know what most students think about the main cause for death. And I have another quick question. So then who do you think kills more people? Communicable diseases or non-communicable diseases? Of course, communicable diseases, the numbers come very fast. The numbers come together. So like in COVID, you see real-time numbers every day, how many people are dying in every country, and even in cities in India. And non-communicable diseases will not kill you instantly. It's like cancer, it's like heart diseases. They build up. And that's why the numbers don't come instantly. But, to answer the first one, it's cardiovascular diseases, which is the main cause of death globally. And it's a non-communicable disease. So non-communicable diseases are killing many, many more people in developed and developing countries as compared to communicable diseases. But communicable diseases have the power, and I don't like to use the word power with diseases, but it does have the power to kill more people at a given time than non-communicable diseases. So why do we need global health law? So the category of diseases is communicable and non-communicable diseases. And to prevent, to treat, to give access to every population, every country, we need global health law. How else do we have a standard internationally to deal with communicable and non-communicable diseases? It is the global health law which will give us those standards. Also, because health is one of the most important conditions for human well-being and human dignity. If you're not healthy, it's very difficult to achieve or conquer anything. Growing up in my Hindi lessons, and I'm hoping and sort of assuming that everybody understands Hindi, I learned something when I think I was 12 or 13 in my Hindi lessons that said, Pehla sukh nirogi kaya, which means that your body and soul will not be happy. There is no bigger happiness and peace than having a healthy body. And that's what the underlying principle of global health law is. Also, people say that we can have national health law, we have state health law, and in India also under the constitution, health is a state subject. The states can make laws as well. But we need global health law because globalization has so many implications on health of people worldwide. And COVID is a very big example. It started from China, but it took no time to spread because China has big businesses with so many countries in the developed and developing world. People were traveling in and out of China. It started from Italy, then it went to Iran. It started just spreading, and it's why? Because it's globalization. So we do need an equal footing, when the implications on health of globalization. So we also need something to resolve that, and that is global health law. And law also has very important role to play at international and domestic levels, because a global health law gives you standards, guiding principles to also develop laws in your country at the national level. It helps understand the science behind it, why do we need the law, and how we can respond to those problems in future. You know, there has been traditional focus infectious diseases, I'm sure, since COVID-19 outbreak. A lot of you have heard of the Spanish flu in the 19th and 20s, which also spread across the world, killed so many people. And since then, and even before that, the international community has been discussing and talking about international standards to control this. There are obviously, like I said, non-communicable diseases, which a lot of times come from lifestyle, environment, urbanization, globalization. And then there's a lot of international trade and commerce, and we'll come to that a little later, and that how everything gets impacted, and that's why we need a global health law. What is the scope of global health law? It's vast, of course, but we restrict ourselves to WHO core principles because it's an international health body with 194 member countries as a party to the WHO. That means they've agreed and acceded to what WHO principles, policies, and guiding recommendations would be. WHO has certain core standards, and there are certain core laws which govern the health internationally. And when I say core, it is that they directly impact health of human beings across the world. So under WHO, there is only one international convention, international law, which is binding, which is a framework convention on tobacco control. Tobacco is considered one of the biggest and the #1 killer in the world because a lot of diseases stem from tobacco consumption. So there is an international law on that. It has about 185 parties ratified the law. Then we have international health regulations, which were drafted in the 1960s, but they were revised in 2005. These are also binding on all WHO members, which is 194 members. And there are certain recommendations which WHO gives and guiding principles on various aspects of international health. And then there are human rights laws and human rights treaties, which have direct link and direct discussion on right to health. But there are also related regimes and related international organizations and conventions which have an impact on right to health, because a lot of these conventions and laws talk about human right. And human right and health go hand in hand. If we separate them, we can either achieve a complete human rights perspective or a right to health and dignity comprehensively. The core of global health law, like I said, is WHO, because we're talking about global health. So we have, talk about World Health Organization. It is the World Health Organization that has laid foundations, brought countries together to work on international health standards, given the science, working with several scientific institutions across the world to understand the problems, to develop science, to develop evidence. And based on that, bring the countries together, develop international law, do the discussions, do the advocacy, release important information like you've also seen in the COVID times. And that's when you realize the relevance of organizations like WHO even more. And not just WHO, all UN agencies have an important part to play here. And the WHO Constitution, which was developed in 1946, itself says in its preamble that health is complete physical, mental, and social well-being, and not just merely absence of health, absence of a disease. Just because I don't have a major disease doesn't mean that, I have complete enjoyment of good health. It means that it is complete well-being of a physical and mental balance. And the enjoyment of highest attainable standard of health is one of the most important fundamental rights for every human being, without distinction or discrimination of race, religion, political belief, economic or social condition. And this was reiterated again and again in several international human rights treaties and laws going forward. So the WHO gives the organization, certain powers to develop laws. The countries come together. There's a World Health Assembly every year with all the member states, 194. They come together, they discuss issues, issues on international relevance and international health concerns, and decide, ponder upon, deliberate what laws and treaties and conventions and recommendations and guidelines need to be developed. So WHO's constitution, Article 19 gives it the right to adopt treaties. So it has only one treaty, which I just explained, Framework Convention on Tobacco Control. But it also has a duty and a right to regulate other health-related matters, and international health regulations, which were revised in 2005, are developed under that article. But Article 3 also gives WHO a right to develop non-binding recommendations, which means these are recommendations. The parties come together to develop them. They largely agree with them, but they're not binding. They don't have an international instrument where countries ratify. They're more like recommendations. Like even in Indian law, you have bare acts, you have legislations, you have notifications, but then you also have guidelines, you have schemes, you have plans. So that doesn't mean you don't have to comply with them. You don't have to, obey those guiding principles and schemes, but they're not binding in nature. They don't have sanctions. Under WHO, there are several. There's Pandemic Influenza Framework, which is a framework developed after H1N1 pandemic broke out in 2005 in the world. Then there's also a WHO global strategies to reduce harmful use of alcohol. Then there's strategy on diet and physical activity. There's a global plan on disability. One of the first codes was on marketing of breast milk substitutes. So there are different kinds of legislative powers which WHO has to enable global health law. Under the binding instruments, like I said, there's international health regulations and the FCTC. But there's a difference in how they are implemented. International health regulations are to control and prevent infectious diseases because they bind all members. They have all hazards approach. They have to report if they know a pandemic has emerged within 24 hours. And WHO, after its research and confirmation and with enough evidence, has the right to declare a disease or an outbreak as a public health emergency of international concern, make recommendations, but it has no sanctions. And when we're talking about international health regulations, it was, I'm going to bring in the COVID-19 relevance and the scope as and when we are going through these slides, because as of now, we don't have an international law dedicated to COVID-19 or an international guideline or a recommendation legally binding with respect to COVID-19. But when you look at this, international health regulations, and you think about COVID-19, does something come to your mind? Look at report within 24 hours. It wasn't reported within 24 hours when it was understood by China that it is becoming a pandemic. It's spreading so fast. There was a delay in understanding and reporting, and that's why the pandemic spread to the scale it did. Reporting will not control the pandemic to the extent that it will just remain in one country, but it can control the spread drastically to a great level. Then we have binding instruments for non-communicable diseases, non-infectious diseases. And it's difficult to pinpoint a specific disease, but all the non-communicable diseases, and if you're a tobacco consumer, can be interlinked. And because tobacco is a product, there's an industry, there's marketing. It's not just a virus, which cannot be regulated. The international community thought that it's killing, it's one of the largest killers, the number one killer in the world put together, all the diseases. Plus, there is a tobacco industry, there's heavy marketing, reaching out to the population. So it's important that there is a law to regulate that. And I'm sorry, it's not 181, it's 185 state parties ratified that. India is one of them. That's why India also has a national law on tobacco control. It has very, very comprehensive provisions on demand reduction, because tobacco has always been a legal product, so you can't really ban it. There's signs that it has adverse effects on your health, one of the number one killers, but you still can't ban it. Something which has been a legal product for years, because then it will lead to illicit trade of tobacco, which will be worse. And we've seen that it has had happened in certain states or related to certain products. The Framework Convention on Tobacco Control has its provisions, but it also has Conference of Parties, which is all the 185 parties meet every alternate year to discuss if they need to deliberate on a specific provision, if they need to include something new, like for example, the e-cigarettes and heated tobacco products are new products launched by tobacco industry. So, the COP, the Conference of Parties, discusses these things, develops guiding principles. It does not have punishments or sanctions, because that's not WHO's role to punish countries if they're not, complying with international laws. But it gives you enough teeth and footing to develop a comprehensive national law where you can have punishments and sanctions. And it has happened in many countries, and a lot of litigation and court cases have happened where the governments and the public health advocates have won, and the tobacco laws have been stricter and stricter. And then there are guiding principles and international standards which are laid down on several aspects of health. For communicable diseases, there's AMR, antimicrobial resistance. There is a sharing of samples, which is talking about PIP framework. Slightly similar to the context of COVID-19, but it was developed especially for influenza. It was more about how you need to share samples of viruses and pathogens without wasting any time, so that vaccines can be developed. But going further, also those vaccines are available to every population. If the vaccine is, for example, being developed in Australia, because they have the funds and the expertise, but the vaccine has to be available in Indonesia and Bangladesh as well. Otherwise, what's the point of developing a vaccine to control a global disease, but it's not available globally? So that was the point of a PIP framework when it was developed in 2000, developed and adopted in 2011 by countries, all the WHO members. For non-communicable diseases, the WHO is already working on certain plans, which is treating, regulating diets, alcohol, physical activity, looking at health comprehensively. And then there are other global governance frameworks on illicit trade of falsified medicines, and pharmaceutical research and development and investment on health. But what is right to health? And like I said in the beginning, if you don't discuss health as a right, as one of the most fundamental rights for a human being, you can never treat, prevent, and make treatment accessible to all for any disease. And there are certain core components developed by WHO when we discuss right to health. It's availability, accessibility, acceptability, quality. If you don't have sufficient quantity, of public health facilities, treatments, services available to a larger population, I just give an example of developing a vaccine in Australia, but not making it available to countries which need it the most. In quantity, there is, we're never going to solve the problem. And also, you must have heard of herd immunity. A lot of this discussion is happening on herd immunity when we talk about COVID. So what is herd immunity? What does vaccines do? They give you herd immunity. How did we eradicate smallpox? Because eventually each and every person had the immunity against smallpox, polio. Every person got immunization. You see that, several times a year, the immunization advocates do several rounds in the country to give free polio drops. Because even if one person is left, or even if a group of persons is left in a small town in India, and there's a polio outbreak, it can just multiply many folds. So that's why availability in quantity is very important. But then accessibility is also important. If all kinds of population does not have access to the treatment, then it's an unfair treatment, and it's only treating a specific section of the society, and health then does not, the disease does not discriminate. The treatment and the access discriminate. So it's going to spread, and the spread will be uncontrollable eventually if there's no accessibility to each and every person, on the health facilities, etc. There has to be accessibility. There has to be respect for medical ethics, culturally appropriate. It has to be sensitive to gender. It has to be sensitive to race, to a country, to an ethnic group. So, and it has to be of highest ethical standards. And the quality has to be of, again, high standards. It has to be scientifically approved. There has to be enough research done. For any law, you need empirical research to be done, because how do you know it's a problem? We know it's a problem, and that's why we're making a law to control that problem. And in health, it becomes even more relevant, because you need proper data points, proper research to establish that this is a big problem and how we can resolve it. And for that, it has to be scientifically approved. A law, a right, a treatment, anything will be of highest quality if it's well researched and scientifically proved in health. So we, understand right to health is important. And when you look at availability, accessibility, acceptability, and quality, again, we look at the COVID context. Availability, we don't even have public health facilities available in quantity or in quality. There is news, not just in India, in the richest and the most developed nations, that people were being turned away from hospitals. There were countries which had to take extreme calls like, who do we save, a 70-year-old or a 50-year-old? Let the 70-year-old die because that person has a series of diseases, and a 50-year-old may have a longer life. Let's save that person. These were not easy decisions. So there was no availability. Accessibility, not really. I know a lot of people in India, and it was only yesterday I was talking to a friend, and she got some of her domestic help tested, and more than 50% of them already had COVID, but they never realized. Thankfully, they were asymptomatic, and the symptoms were not really, really terrible. But even if they had fever, they didn't have any access to testing. Either the testing was too expensive or were not available in their area. And because the symptoms were not very serious or very crazy, so nobody was really paying attention to giving access to them for treatment or testing. Acceptability, for that, there has been a lot of racist remarks. There has been a lot of non-acceptability of certain standards which WHO and scientists and doctors have announced: wearing masks, respecting other medical ethics like social distancing, washing hands. A lot of communities are not taking up to that. We've seen a big uproar in the US for wearing masks. And quality. Quality of treatment, quality of vaccines. Quality of treatment in COVID is very, very low for most population, because the public health facilities are overwhelmed, because the countries, the governments were not ready to manage such a pandemic. And with populations, people not understanding and respecting the ethics and the importance, the spread happened multifold. So right to health has to be seen as as a human right. Unless and until we see it as that, none of these core components would fall in place, and there will not be equal treatment for all. We won't be able to prevent diseases, and there won't be any equality even in health going forward and even now. So why do we say right to health is an important human right, or why right to health are human rights, a part of human rights? Because right to health, the right to highest attainable standard of health is very important. It's a legal obligation. Countries have to ensure health for all people without discrimination, like I said, and without discrimination on gender, caste, age, country, race. Any kind of discrimination for health is unacceptable. These rights are inseparable from other human rights. So right to food if you don't have right to food or housing or education, how do you have right to health? They're interlinked. So you can't separate right to health from human rights. And that's why they're completely interlinked, and you have to see right to health as human right. The right to health also gives one a freedom to have control over one's body and to be free from any kind of interference. And that is a part of human right. But it also entitles every individual to have a right to a system of health protection, a treatment. And like I said, all these principles go hand in hand when because they have to be based on non-discrimination, and all population has to be protected. But disadvantaged groups have to be looked at, especially because they are the ones who are not represented, do not have access, and are not, and completely sometimes wiped out from the scene. And in COVID, I'm just going to give you a very, very big example is migrant workers. Not just as health, overall, their human rights were violated since the pandemic outbreak in India. The lockdowns were announced. The employers didn't pay attention to them. They were not quarantined in good facilities. They didn't have access to food and water. In several locations, civil society came together, made extensive efforts. But migrant population workers was this one disadvantaged group which came out very apparently in COVID outbreak in India. In other countries, it was either people who could not afford treatment, older people. But in India, one of the biggest disadvantaged groups was migrant workers. And could the situation be avoided? Of course, slightly, not completely, but slightly. Things could have been better for them, but they were not made better because their right to health was not really seen as right to human rights. There are other core human rights treaties. I'm not going to go into detail. And being law students, I'm sure you know all of them. You've studied some of them. But the two most important ones are International Covenant on Civil and Political Rights and International Covenant on Economic, Social, and Cultural Rights. And very quickly, we'll see how these two international treaties very nicely and very well define right to health as human rights. Because it gives us right to life, prohibition of torture, freedom of expression, right to information. In COVID-19, right to information has emerged as one of the most important tools. If you don't have information about how to protect yourself, how to protect your family, how to get treatment, it's a big mess. And especially in pandemics, especially in communicable diseases, because they spread so fast, right to information is very, very crucial. And under economic, social, and cultural rights, right to health, food, like I said, right to health is inseparable from other human rights. So, after right to health, you see right to food, adequate standard of living, social security, scientific progress, education. There are human rights which are interlinked to right to health. So we can't see right to health separately from human rights. And in global health scenario, these two have to go hand in hand. Because if you see health just isolated, there will never be any comprehensive standard for good health attaining the highest standard for health. And it's not that we've seen pandemics only now. I said there was obviously Spanish flu and bubonic plague before the WHO came into place. But even after when WHO came into place, there were UN agencies. We've seen pandemics across the world. We know Ebola, we know HIV, we know TB. All communicable diseases. The civil society, WHO, a lot of international agencies, governments have worked together to develop guiding principles. It was a gradual process. Things did not happen in a month or a day or a week. But because enough time, money, science has been invested in working on Ebola, HIV, and TB, those lessons have to be taken into account when we're talking about controlling and preventing COVID. Because, scientists have been saying that. CDC in the US, the Chronic Disease Control Center, the WHO have been saying that this is just the start. It's, COVID-19 is not the last disease or a pandemic which is going to touch the world. It's going to get worse. And going forward, we may not be able to control these viruses and pathogens from, from emerging. But what we can do is two things: work on our health. And how do we work on our health when the state, the government, treats our health as a human right? And number two, building our health systems. And again, for that, you need standards, because if we have strong, comprehensive health systems, we can at least respond to these pandemics. And for that, we need certain standards, certain policies, certain laws. And enough research has been done previously on pandemics. And it's very important that the international community and the countries take note of that and learn these lessons. Reduce all health inequalities, like, we've learned in TB, in HIV. There should be access to treatment and services for all. In TB and HIV especially, access to treatment has been terrible for disadvantaged populations earlier. And that's why certain standards were developed. Human rights have to be considered while developing all policies. Like I said, you can't see health ever in isolation, and engage all stakeholders, not just the government, not just the scientists, but also the vulnerable population, understand their problem, what's going on, how do they respond to the treatment, and only then we can develop something very, very comprehensive going forward. So what we can do, when there's an outbreak in the future, and even right now when, we're dealing with COVID, states have to be prepared to respond to the next public health emergency, and the preparedness has to be there. And there are enough international standards to lay foundation for that, like international health regulations help you lay standards for preparedness. And COVID-19 is this, knee-jerk event for the whole world. Any country, no country is spared, whether it's the US or France, or whether it's Vietnam and India, no country across the world is spared. So this is a big lesson where countries can come together and start working on preparedness, like they've done in influenza, like they've done in TB, they've done in HIV, now they need to do it in other pandemics going forward. And there has to be two parallel approaches going forward. There has to be human rights law, which need to be looked upon. Many countries, including India, is a signatory to several human rights treaties. So everybody needs to understand what their obligations are under right to health. Incorporate that in their national laws. Develop national laws if they're not there. Because we need to prevent and control infectious diseases and build our health system side by side. And keep WHO international health regulations as your core principles. Develop core capacities, develop core laws if need be. Develop guiding principles under international health regulations. And there has to be compliance by all states. Obviously, there are several laws. We know in India, implementation is terrible for certain laws. And it's the standard everywhere. Some countries will comply very well. And I've worked extensively in Framework Convention on Tobacco Control, and that's where I can tell you. For example, Australia complies with the FCTC comprehensively, and so does Turkey, which is a developing country. But there are certain other countries which would not. China would not comply, or Mongolia would not. So countries have to comply if they sign a treaty, because that is the human rights accountability. If you don't comply, how do we hold you accountable? How are countries accountable? How are governments accountable? So in the end, I'm going to finish my presentation, my talk, and say that health has to be seen as human right, and more in this globalized scenario. And COVID-19 is the best or the worst example to understand this. Thank you so much. I'm very happy to take questions now or later as Professor Dave and Omar see appropriate. Thank you so much.
Thank you, Priyanka, for your wonderful speech. I think it laid the correct temperament, and the framework for going forward in discussion. Without wasting much time, let me introduce Professor K.M. Gopakumar, who is a legal advisor and senior researcher with the Third World Network. Third World Network is an independent, not-for-profit organization that carries out policy research and advocacy on issues around trade and development. With a focus on third world countries. Gopakumar's work in Third World Network is focused on patents and access to medicines. Gopakumar sir, I would request you to share your views about the current topic. Over to you, sir.
So thank you for this opportunity to share the views on the response of international health law from a development perspective. Am I audible?
Yes, sir.
Yeah. I'm not sitting on the video because there might be some bandwidth. Maybe towards the end of the presentation. Yeah. Thanks, Priyanka, for taking the stage, and as he has given a good landscape of the global health law, I'll confine myself to the international health law, which is relevant in the context of COVID, very core sort of instruments, not the whole body of international health law. When we talk about international health law, it is mainly the law framed by the nation states. When we talk about, as all of you know, that there might be some regulations, some guidelines, developed by even non-state actors also can be qualified as global health law. So let me move to my next slide. So anyone can share the slide? Hello?
Yes, hearing it, sir.
Could you, yeah. So we can directly move to the second slide. The first slide is, yeah, we can move to the second slide. So why do we need international health law? So there could be various reasons, but one of the important function of international health law, or the rationale at the time of framing these laws was mainly to facilitate coordinated action. So next slide, please. So I'll be focusing mainly on that perspective. So if you look at the core of international health law, I'm just confining to three set of instruments. First is the UN Charter, and second is WHO Constitution and International Health Regulation, and lastly the Human Rights Law. So that also, the rationale which I explained to you, to facilitate a coordinated action. So Article 55 of the UN Charter basically creates an obligation on the UN. It says, with a view to the creation of conditions of stability and well-being, which are necessary for peaceful and friendly relations among nations, based on respect to the principles of equal rights and self-determination of people, the United Nations shall promote. So there is an obligation on the United Nations Secretariat as an organization to promote a few things. So those points are relevant to our discussion. The first one is the solution to international economic, social, health, and related problems, and international cultural and educational cooperation. So the health is mentioned there, and also second one is the promotion of human rights. So both these principles are relevant in the present context. And you also know that many of these UN specialized agencies are created in a way to implement some of these things. So let us move to the next slide. Then UN Charter also creates an obligation on the part of member states, and it says all members pledge themselves to take joint and separate actions in cooperation with the organizations for the achievement of purposes set forth in Article 55. So to translate this into the concrete situations or context, basically says that if a UN resolution is adopted, UN General Assembly resolution is adopted, then a state member state is bound to implement those resolutions. So again, there are certain scholars, they may argue that UN resolution of the Security Council is of much higher normative value than the UN General Assembly resolution. The first one is binding because there can be consequences if you don't follow those, but UN General Assembly, there is no consequences. But from a normative point of view, the General Assembly resolution basically creates an obligation on the part of the state to act as per Article 55, Article 6. Then that takes us to the next slide. That's a human rights framework. Next slide, please. Yeah, next slide. I already mentioned Article 6. Next slide, please. Yeah, that's on human rights. Priyanka already mentioned you have a range of instruments, but I'm just focusing on the Article 12 of the International Covenant on Economic, Social, and Cultural Rights, which spells out the right to health obligations. Article 12 gives a specific paragraph 2 gives a specific obligation on the part of the state to for the prevention, treatment, and control of epidemics. Next slide, please. Yeah, this is a less talked about right. That is Article 15, which talks about right to science. The right to science also says that the state has an obligation to ensure the enjoyment of progress in a pandemic context, what happens is that way of enjoyment of both come in and after enjoyment of.
Sir, your voice is breaking actually. Hello. Hello.
Gopal sir, you're not audible.
I think he's disconnected.
Yes, come again.
Okay, he's back again.
Hello. Yeah, I think
Yes, sir.
There was some connection problem. What I'm saying is that the framers of the international health regulations as well as WHO members are very much aware of the fact of public health measures on human rights, and therefore there's a specific provision in the international health regulations to implement fully respecting the human rights. So just keep these things in mind, and then let us move to the next slide, that is the WHO related instruments, mainly the WHO Constitution, which gives a mandate to the organization to act upon in order to achieve its objective and functions. That the function is mentioned in Article 2, and one of the functions of the organization is stimulate and advance work to eradicate epidemic, endemic, and other diseases. So there could be other. There are a few other points mentioned in Article 2, also equally applicable in the context of epidemic, but this is the direct reference in the WHO Constitution. Then to translate the function, WHO constitution mentions Article 19. There is you can frame the international treaties related to the public health, and Article 21 talks about the certain regulations in 4 areas. So one of the areas is sanitary and quarantine requirements and other procedures designed to prevent international spread of so based on the mandate given or under the Article 21, we have international health regulations. So now what we have is the international health regulations of 2005 version. There were previous versions of international health regulations. So let us, just before moving to the international health regulations, to sum up the point is that the UN Charter basically creates an obligation on the part of member states as well as on the organization to act collectively and in a manner to promote health. And human rights also talks about creates an obligation to address the epidemic, but also to address the rights. When you try to address the human rights aspects of the health, you should also have an obligation to ensure that the measures you have taken and to address the human rights or the measures you have taken should not affect not only the people in your country but also in other countries. So there is an international aspect to the obligation. And thirdly, when it comes to the WHO is mindful of the human rights obligations and its impact on human rights when you take certain public health measures. So the obligation on the part of the WHO as well as on the member state to one of the principles of implementation of international health regulation, which basically put the regulation of the quarantine and sanitary measures to take into consideration of human rights. So now let us move to the next slide. The IHR. All of us are aware of this instrument because there are so many writings in the last 6-7 months about this instrument. It's basically an instrument which regulates the quarantine and sanitary measures. When it comes into play, it comes into play whenever there is a public health emergency of international consequences. So who makes that decision? That decision is made by a committee, Director General of the WHO based on a recommendation of the committee. But that committee recommendation is, is not binding on the DGP. He can either disregard the thing or disregard the recommendation or accept the recommendation or even overrule the recommendation and can even declare an public health emergency. The members of this committee the members of the committees are in a way the panel, the pool of experts are nominated by the member state, but the final selection is based on the description of the Director General. So what kind of obligation it creates on the member states? The member states creates a specific obligation to report any kind of outbreak of diseases or even within your border or which you which have come not originated from your border but which is present in your border. So it creates an obligation to report. Once that report comes in, that it starts an appointment of the committee and assessment of the evidence, and not all, once it is notified, the member state also has an obligation to share the information, all information with the WHO. Once the committee recommended or not, once the WHO, not the committee recommendation, once the WHO makes that decision, then it basically uh, obligates WHO to come out with that temporary recommendation or recommendations of much more permanent in nature. But in any case, these recommendations, there is slight lack of clarity uh, with regard to the obligation on the part of the states to implement those recommendations. We'll come to that later. And the states are also free to take certain measures which goes beyond the recommendations of the WHO, subject to certain conditions. The next slide, please. Sorry, just the same slide. Let us. So when we compare this IHR 2005 with the previous IHRs, the current IHR is in a way disease neutral. Earlier, the IHR versions were very much constrained to certain types of disease. Now, it includes any type of public health emergency, even coming out of an environmental disaster or a nuclear disaster, not only constrained to certain types of disease. So that's why it is neutral, and it is so the scope is much more wider. And most importantly, it also gives more powers to the Director General, including the power of the Director General to seek information even from the non-state actors, not from the states, because states might have a reluctance to share sometimes this information. And DG has much more power to appoint the emergency committee and even to, as I mentioned earlier, not to bound by the recommendations of the committee. So the DG is the real the person, the real person who has much powers under the IHR. The next slide, please. So till now, the 2005, the IHR was adopted, came into force in 2007. We have including COVID-19, we have instances of international consequences. In the 6 things, around 3 times the WHO came under criticism for the manner in which it declared the public health emergency. One, the first time it was criticized for acting too quickly, okay, without much evidence. The second time and the third time it was criticized for acting slow, even though there was evidence, but it was acting very, very slow. So that's one of the important criticisms. Why this criticism is coming? This criticism is coming because the lack of transparency in the decision making. What is the lack of transparency? Because as these decisions are made by the, based on the recommendations of the public health emergency committee. The minutes of this committee is not in the public domain. You have an outcome document after each time the committee meets, but you don't know on what basis and what kind of evidence the committee considered and take a decision to make such recommendation. So that is not available in the public domain. So that's why you do not come to know whether you might have read all this criticism about WHO delayed the declaration of the public health emergency. So we don't come to know whether such delay occurred or not in the coming days, because these minutes of the committees are not available in the public domain. Second, non-compliance of WHO recommendation, which I already mentioned to you. There is a lack of clarity with regard to that, and there is also the obligation is to inform within 24 hours. But in this case, it shows that China has not informed within 24 hours. But we will not come to know for sure how much when China was exactly aware of the situation and when exactly reported and whether there is a delay occurred. Okay? And so that is we will not come to know from the WHO sources, but there is also an obligation to share the information. But the leak emails and the telephone conversation transcript published by Associate Press shows that there was some reluctance from the part of China. The information were not coming through, and the Secretariat was trying to pursue China to get that information rather than confronting. So this much we know. So this is again another shortcoming of the instrument. And third, going overboard under Article 43, because the WHO never recommended travel restrictions, but many countries adopted travel restrictions. And many times, many of the other recommendations of WHO was not followed. For instance, there was a recommendation for social distancing, there was recommendations for lockdown. Many countries did not follow. So we don't have a mechanism to enforce the recommendation. Okay, so we can basically say that the IHR is a legally binding instrument, but its enforceability is doubtful. Actually, there is no mechanism existing to enforce the recommendation of the WHO. Though there is an enforcement mechanism, there is a dispute settlement mechanism between countries that nobody has used it. I don't think so. In this case, also anybody is going to use it. And last point, which I put it in bracket actually, related issue with the binding but not enforceability, is the accountability of the member states. Normally, the human rights treaties, you don't see any mechanism to enforce things. Of course, there are exceptions like protocols, but the main treaty, you don't find any mechanism to enforce the provisions. But one of the indirect way of enforcing is to seek detailed report from all the parties. Even though there is an obligation in IHR to submit report as and when requested by the World Health Assembly, but this report, there is no detailed format for filing those reports, and therefore we do not know what exactly the level of implementation of IHR by various member states. So next slide, please. So this slide, I'll just mention a few structural issues related to the IHR mechanism. The first thing is that in the IHR, it creates an obligation apart from the reporting to build more capability to meet the challenges of a pandemic or an outbreak of disease. But here, the core capacity, you cannot build that without having a robust health system. If your health is public, if your health is privatized, and there is a lack of public health infrastructure in a country, then that country may not be in a position to develop that core capability to meet the health emergencies. That is exactly what we are witnessing, or we are seeing in many developing countries, including in our country. So the core capacity, around 2/3 of the WHO member states have not developed core capacity, as per their reports submitted, our assessment made by one of the HR review committee. Then, second issue, silence on the health products. You need various set of medical products to respond to the emergency. So here it is only a IHR is now working as only a mechanism to give alert, and then there is a set of recommendations. But there is nothing to ensure that that recommendation can be implemented, a response can be built with the availability of medical products at an affordable price. So that part is silent. So then that part will be filled by other instruments as well as the market. So that can create problems in your response to response to the pandemic. Third, lack of financial resources. When WHO does not have enough financial resources to implement IHR, when many countries who are part of IHR do not have the financial resources to implement. Second last point is the health security agenda. Pandemic or the IHR related issues are very closely associated with the health security agenda. The moment you talk about health security, it is very closely linked to the military agenda. So therefore, there is a lack of trust among the member states within WHO to share information related to outbreak of diseases, because it's very closely linked to the biowarfare and other related issues. Then there is structural weakness of WHO. The WHO, all of us knows that it's a multilateral organization, but its financial health is not that healthy. 2/3 of its financial budget is coming from the voluntary contribution from various member states. So as a result, the agenda of the organizations are controlled by those who donate the money, not the whole membership are not setting the are not really setting the agenda. So this affects the WHO's capability to point fingers at member countries or to pursue an agenda which is from a public health point of view much more robust agenda with regard to the implementation of IHR, for instance, to building the health systems in countries, etc. So that takes us to the next slide. So when we look at the UN and WHO response during this pandemic, what we have seen is that from the UN General Assembly, there are 2 resolutions already adopted. A 3rd resolution is currently under negotiation, and UN Security Council also passed a resolution. But one of the focus of this resolution is to one of the resolutions from UN General Assembly is to address the shortage of medical products. Even WHO resolution also addressed the issue of shortage of products. But what we find when it comes to implementation with regard to the issue of shortage of medical products, ideally, what's the reason for shortage? The reason for shortage is that production is concentrated in a few countries. So you need either to scale up the production in those countries, or you have much more decentralized production mechanism. Right? From a sustainability perspective, you should have much more a decentralized production of medical products. How do you ensure the decentralization of medical products? You have to facilitate technology transfer. You have to overcome the barriers created by the third regime. You have to overcome the barriers erected by the international intellectual property. This is the way you can build a much more decentralized product, and that will ensure accessibility, affordability, and it increases the competition. But the solution promoted to implement this, the UNPA resolution or WHO resolution, is creating further concentration, because it does not encourage the technology transfer and decentralized production. So there is one more slide I want to touch it upon, not there with Umar, that is related to the PIP framework. The PIP framework, as Priyanka mentioned, is applicable only in the case of influence of pandemic influenza, not applicable to the COVID. What is this framework is doing? The framework is basically regulating the way in which the virus sample sharing happens in the case of the viruses related to the pandemic, influenza virus, sharing of influenza virus of pandemic potential. Why these conditions are attached to the sharing of virus? Because it's the way to implement Convention of Biodiversity. It regulates the access which makes the access conditional. That condition is to share the benefits. So you need virus samples, even in the case of COVID, to develop vaccines, medicines, and diagnostics. Once you share these samples, on what benefit you are getting, if that access and benefit sharing are not linked, then there will be free access and there is no condition, there is no obligation to share the benefit. As a result, the products can be very costly. So there could be some kind of condition or some kind of condition to be imposed on the companies when they access these samples. Okay? That is missing. So now to conclude, the last slide is that the weakness of international health law is basically affects the COVID-19 response. These weaknesses are structural as well as implementation level. And second point is that the weakness of international health law is also emanating from the international economic law. It sets a certain obligations like intellectual property or even films related or trade related obligations, which in a way incapacitate developing countries to respond to the COVID-19 in an effective way. So the response of international health law to pandemic, to COVID-19 pandemic is in a way suboptimal. Thank you.
Thank you, sir, for your thought-provoking speech and introducing us or getting us deeper into the whole scenario of international health law. Now, we would like to take some questions from the participants. Many of them have posted their questions. So, Priyanka, if you can answer the question which was asked by Pulkit Khare. He says that in the idea of health being inherent to life with dignity, could we source an international health law through the right to life in the ICCPR or any other enforceable international treaty?
Sorry, I was on mute.
Yeah.
So absolutely, Pulkit, and ICCPR, WHO preamble and international health regulations, when you read it together, you get the answer. You don't read laws in isolation, especially international laws, absolutely. But the point is that the governments, the states, the parties, countries have to make their national laws robust to have, you know, right to health and right to life with dignity as a core component of their constitution and national laws for it to be more effective. Because international laws give you a platform, a standard, a foundation, but the countries have to comply with it, keeping that in mind. But it's very well laid down in international law otherwise.
Right, thank you. Now another question which is I would like to pose to Gopakumar sir, and this is about the global health law, whether it is matured enough to address the north-south divide. That is what Shyam Kumar is asking. Sir, if you can answer that question. Sir, you are on mute, sir.
Repeat the question once again.
Sir, it says that whether global health law has matured enough to address the north-south divide.
So there are certain instruments, there are fundamental or structural issues which need to be addressed to take into consideration or take on board of the concerns of developing countries. So one issue I mentioned to you is related to the core capability mentioned. It's an obligation under the IHR. But many developing countries, there is hardly any health income. If you do not have any health income, you are not, it is foolish to expect that them to to address the outbreak of diseases. Of course, as we have seen in the case of Ebola outbreak as well as COVID outbreak, you set up something quickly, and um, uh, then after the emergency is over, it all goes back, or in another way, it delays your response. So these are some. This is one clear example of a structural issue which affects the implementation of IHR, or which compromises the ability of developing countries to respond to an outbreak of disease. So we need to address this structural issue, which is not addressed in the instrument. Second, there are issues like there would be issues related to the implementation of the implementation issue. By implementation issue, I mean there is a provision, but it is not implemented properly. So, for example, of this virus sharing, you don't need another instrument for that. There is a convention on biodiversity, which ensures that access is conditional upon the obligations on benefit sharing, but nobody is implementing it. Or organizations like WHO should say that there is the core obligation under the international law, and any kind of virus sharing should respect that. But WHO is not doing. So it's an issue of implementation. Thank you.
Right, sir. Thank you. Priyanka, now there is one question from Yashi Jain. It's more of a conceptual sort of question. Like, who focuses more on prevention? WHO focuses more on prevention of diseases or its cure. So, what is the mandate actually of WHO?
The mandate is both. WHO itself does not develop the cure or have labs developing vaccines, but they have something called the WHO Collaborating Center. So they work with laboratories and institutes across the world, make them their partners and collaborating centers after due diligence and research. And the collaborating centers and institutes and research institutes then work on developing cures. But just say, for example, if we are talking about a vaccine, and if you see the Indian context, Serum Institute based in Pune is working on a vaccine. Once the vaccine is developed, human trials, etc., are done, then there is a WHO SAGE committee which has scientists from all over the world, and then they will look at the vaccine and give its approval and clearance. So WHO is a holistic health organization. The mandate is, of course, prevention and cure, but they're not a research institute or like a laboratory who will make the cure themselves. But of course, that's a part of their mandate.
Right, ma'am. Now, going further, Priyanka, there are Asmita Patel has asked a couple of questions. The first one she's asked is, what are the issues that India need to address from the perspective of law in context of public health emergencies? What are the challenges that are specific to India when it comes to regulate such emergencies? Priyanka, if you can answer this question, and Gopakumar sir, if you can, add on to what Priyanka says about this particular question, because this requires, careful consideration. Priyanka, please, if you can.
Absolutely, I can start with it, and he can add on to it. So India is a part of World Health Assembly, and a party to WHO, and India is also a party to most of international health conventions and the Framework Convention on Tobacco Control, etc. So international health regulations and other international health standards lay down the foundation. So India can adopt them, in terms of a health response. But more than developing a new law or working towards that, what India needs to do is build its public health systems. Obviously, the problem has been curbing the spread of the disease in the COVID context, but that's also because of our population In our urban slums, we cannot really do social distancing, access to water, etc. Access to water, social distancing, enabling that in urban slums cannot be achieved in a few days. But what needs to be done by Indian government is making a robust public health system so that it has the capacity to treat and take on more people, work on equitable health systems. And in India, of course, we don't have equitable health systems. The private healthcare, which I think about 75 to 80% Indians use, is not affordable to all. Comparing Indian salaries. And the government system is always overloaded. There are vacancies, the supplies and the doctors are not there. So a robust health system is something what we need immediately. And India does, as a country, and the constitution, we do treat right to health as a fundamental right under right to life. So the concept is there, the principle is there, but now it needs to come in implementation through state governments also, and through robust public health systems. But a big challenge in India was also the no tandem between state and national government when we saw COVID. Because your question is big challenges. You saw the migrant workers' plight when it happened. They were completely abandoned from all aspects, from food security, employment, treatment, quarantine, distance, reaching their homes. So it has to be equitable. It can't be discriminatory, and the disadvantaged populations have to be taken into account when any of this happens ever again, or even right now.
Gopal Kumar sir, if you can add on to what Priyanka said.
Yeah, of course. What we have seen is that whatever the legal instruments currently our authorities are using for which there are very two important instruments. One is the Disease Prevention Act, that's like a 19th century legislation, which is around 2 pages, I guess. And then we have National Disaster Management Act. So much of the acts are coming from the National Disaster Management Act. Why? Because the other law is, as I told you, it's like a 19th century law. There's Epidemic Act, actually, 1888. So this law, the punishment is very less. The scope is very much less. So that therefore, as India is a party to IHR, especially IHR 2005, this law does not fully, the current law does not fully fit into the IHR framework, because the scope of IHR is much bigger. So that's why even while implementation, our governments are, our various state and central governments are exercising its powers under the National Disaster Management Act. So there is an attempt actually to come up with a new legislation. So it's called Public Health Act of Public Health Act, Indian Public Health Act. So this is presented before the table before the Parliament and went to the consideration of the committee. So this was in 2018, I guess, but I have not seen the committee report. But the scope of this act is much more bigger than the current Epidemic Control Act. So there are attempts to have a new legislation in India, which will basically align our legislation with the ISR 2005. So currently we are using the old act. So that act will be repealed after the adoption of the new act.
Thank you, sir. Now, sir, the next question is an important question, which I would request Priyanka to respond. How do sanctions affect the human rights situation in the time of pandemic? when such a country under international sanctions and the civilians start suffering from pandemic. So basically, if a country is under sanctions, international sanctions, and pandemic strikes, how would international health law deal with such situation? Basically, that is what the question I can understand.
So the international health law, if you're always looking at, like I said, right to health and right to health as a human right, that gives you enough basis and mandate to respond to public health emergency despite having human rights sanctions. And also health as a response, as a subject, is dealt by Ministry of Health in most countries. And that's why it is very important that countries are working on responding to pandemics or responding to any health emergency or any health issue. Even when it's non-communicable diseases, everything does not come to you in one go because it's not spreading so fast. The way is that countries already develop their national laws in line with what is given in international standards, what's given in international health regulations, and the other human rights treaties like ICCPR, so that the countries are already working and making their systems robust. Because that's what happens when countries don't have systems in place and something like this pandemic comes forth. Even the most developed and a country is not prepared. Case in point is Italy, not with sanctions, but otherwise a country which has a great public health system and a generally healthy population. And I don't know if a lot of people know, but like Italy and Japan are two countries, and they have certain regions where the life longevity is the highest in the world. And despite that, Italy was failing because something like this was absolutely uncontrollable. And people did not understand the importance of social distancing and staying indoors and wearing masks because people took it lightly. There was less research, there was less science. But we all have to take this as a case study and a lesson learned. And, we don't have to keep waiting for new lessons to be taught by, these pandemics. We've had HIV, Ebola, Zika, TB, which were all communicable diseases. So it's important that all the nations learn it from those and COVID and make their health systems robust, have provisions in their national health law, national health policy, however it works for countries. In India, we also have a national health policy. But, develop a pandemic framework, how to respond in pandemics. And like I said, sorry, make health systems more robust.
Right, ma'am. Thank you. Now, next question, Gopakumar sir, if you can answer this again, we'll pose, a later debate at a later stage. The question is, what is the role and relevance of WHO in post-pandemic scenario when there is huge dissatisfaction and trust deficiency of countries in WHO? If you can answer this question, sir.
Yeah, sure. I think we should understand the role of WHO. WHO is the only international organization which has the mandate to coordinate the international health. If you read the Constitution, one of the, I would say, the very wonderful document, okay, which provides all the mandate for the organization. Okay. Then the question comes, why then the WHO come under criticism? So part of the criticism coming from and the fact that structural weakness, the weakness coming from the absence of financial resources to implement or fulfill its mandate. So who made WHO weaker? By and large, its member states. How? First, the developed countries refused to, especially US, refused to increase the access contribution and started financing even many other European countries. So I would say, let's call it the majority of the developed countries to finance organizations through voluntary contributions. The difference is that when an assessed contribution, a membership fee kind of thing, it gives much more flexibility for the WHO secretariat to deploy the resources where they are needed. When it comes to voluntary contributions, you are contributing the money to carry out a specific task. There are actually two types of voluntary contribution: core voluntary contribution and conditional voluntary contribution. Okay, the core voluntary is basically means like an assessed contribution, you have flexibility, but the contribution coming to the core voluntary is very less. So your substantial percentage of the contribution coming from through the conditional voluntary contribution. So that means the entire program or percentage of your program, the WHO programs and its implementations are donor driven. So as a result, to ask for more funds, WHO started looking at other sources, including philanthropic organizations. You might be aware of the fact that the Bill and Melinda Gates Foundation is the second largest donor to WHO. If US goes out, this would be the largest donor to WHO. So accountability and transparency of this mechanism is very problematic. Okay, you can say it's below than the expected level of transparency and accountability. So that results in the trust deficit or the lack of implementation of its mandate, etc. comes in. So partly, I would say it is the structural weakness, and the member states are responsible, especially the developed country member states are responsible for the structural weakness of the organization. And second, there could be issues of related to the leadership and its orientation. Especially in, this is happening for many years, and especially in the current leadership also, this you can see that kind of reflection. What I have observed is that many of the memorandum of understandings or many of the staff or many of its engagements are with the entities or persons who are connected to Bill and Melinda Gates Foundation. So it basically eliminates the diversity of ideas and diversity of the approach when it comes to pandemic or otherwise in many health areas. So this is also another problem. But having all this criticism, I would say this is the time to strengthen the organization rather than do certain steps or taking measures to weaken the organization. So we need an international organization which is accountable to its member states and transparent, and that can be based on core public health mandate. So WHO is an or its constitution at least is an ideal document and ideal institution to carry out that. But as I mentioned, there are certain structural weaknesses which prevents WHO, and to address that structural weakness, the methods and the measures they have taken, the current leadership, is further weakens the organization. But from a public interest perspective, I would say, for public health perspective, I would say it's the time to stand with WHO and to strengthen it, but at the same time asking the critical questions and engage critically. Both the academicians and the civil society should do that. We should get into the details and bring the facts the public domain, and we should bring out the concerns in open. Okay, so that can create certain kind of pressure and persuasive effect on the organization, so they will not get into actions or get into further deterioration. So you can prevent that.
Right, sir. Thank you. Now we are coming to what's the end of the session, because already it's almost 2 hours we have started this particular session. So Just asking, Priyanka, one last question. I mean, although there are a lot of questions which has been posed, unfortunately, I don't think we'll be able to take every question. But there are couple of questions which I found very interesting. One is from Pulkit Khare, and he said that could the international health regulation be triggered even when the disease is endemic? In other words, in an epidemic that isn't yet likely to cross borders, can the WHO suo moto give binding rules to a country?
So, like, Mr. Gopakumar was also saying, we need to understand WHO's role here. WHO cannot take suo moto actions. It cannot send court kind of notices to countries that you need to do ABC. It's made of these countries. Countries meet once a year on general health issues, and then they meet again and again on special health issues. They make executive boards representing all 6 regions of WHO so that there is enough representation. So WHO cannot take actions or send notices to countries, but yes, international health regulations can be evoked by national legislations, in national laws and by countries. And especially, like I said, if a country feels that the disease is spreading and scientifically it covers certain parameters, it's supposed to inform WHO, which is an international organization, and make a press release or a statement otherwise globally. And in this context, China failed to do that, to inform the world in time. So yeah, but it's not that if China failed to do that, WHO can fine them or send a notice or remove them from World Health Assembly. That's not going to happen. So because WHO is more like it gives recommendations, enables, it's a facilitator, it's a sign, it helps you develop the science, approves it, but it can't take suo moto actions like that. But yes, international health regulations can be invoked, absolutely. And like I said, all 194 countries are party to it, China, India, all countries. So they have an obligation under international health regulations to inform the world that there is an endemic, which could be pandemic and could be, of international health concern if it's started in Wuhan and spread in Beijing and then maybe Shanghai. So it has obviously properties of an endemic, something which will spread so quickly. So it's the country's duty to inform.
Thank you, Priyanka. Now, last question, which I would like to ask both the experts, which will be like also ending remarks for this particular webinar, is that as and when, there is a vaccine or a cure, which is, researched or developed by companies, like big pharmaceutical companies, how, international, what do you say, framework or WHO will ensure access of such medicine or such vaccine throughout the world, and how will the patents part play a role in this particular scenario? Gopakumar sir, if you can answer, and then Priyanka, if you can add on to whatever
So the
said.
WHO has two types of engagement in this regard. So the principle is called fair and equitable access of all medical products. For the first thing is we do not have an effective vaccine or an efficacious medicine to address COVID, and we also have an issue of affordable diagnostics. So for that, you need to have to develop these products. So for that, WHO has something called ACT Accelerator. And second, once the product is out, then you have to ensure something called something called fair and equitable access, right? Uh, so what WHO is doing is that one is they are engaging with the ACT Accelerator. So ACT Accelerator has these three pillars. And second, WHO is developing something called a global allocation framework and global allocation mechanism for vaccine, therapeutic, and diagnostic to ensure that it is fair and equitable access. In the case of vaccine, WHO has come out with a document. It's still in development stage, but it's basically laid down the principles of global allocation mechanism for vaccine. It says the first stage, all countries who are part of the global allocation mechanism will get vaccines to cover their health workers. That is, roughly every country will get cover around 3% of the population. Then the next stage, there would be coverage for people who are about 65 years old, that is high risk population, then other kind of risk. So the idea is to cover the global framework. Idea is to cover around 20% of the population through the global allocation mechanism for vaccine. But the problem is that what is the delivery mechanism? The delivery mechanism is through Gavi. It is through the advance purchase agreement. The countries are divided into two groups. The countries who can pay the price for the 20% of the population, they are one group. Then countries who are depending upon the ODAs or getting it free of cost. So there is a confusion, and also countries are also engaging bilateral advance purchase agreement with the vaccine company. So you have certain countries who are entering into bilateral arrangements with the companies directly. Then there are two types of countries who are entering into advance purchase agreement through Gavi. So there is no clarity that all these countries are going to adhere to the WHO principle of 3% coverage for their population for the first tranche, and then they will progressively cover the rest of the population. So in the absence of that clarity, so what is going to happen is that the countries who are going to have the money will get more doses than the countries who do not have the money, right? And second issue of the advance purchase agreement is that, as I mentioned to you earlier, there is already a concentration of production, right? If you get the technology, then you can decentralize the production and you can reach to the people much early than if the vaccine is produced by a few actors. That is still there is no clarity. There are certain efforts going on to have much more production centers. Even I heard that the Bill and Melinda Gates Foundation also invested to increase the manufacturing capability of certain companies, but we don't know the technology will be transferred. Say, for example, in the case of Oxford vaccine is actually manufactured, this license is actually with the AstraZeneca, but AstraZeneca gave a sub-license to Serum Institute to produce the vaccine. As a result, the Serum Institute said that, okay, 50% of the production will be earmarked for India. Fine, good. But how about other countries? Okay, only 50% will go and it will be distributed to other developing countries. Okay. At the same time, AstraZeneca has a direct agreement with the US government as well as with the UK government to around UK, I think around 300 million doses extra. So that shows that the production will take place only in a few countries. Okay, but countries like India might be benefiting because of the Serum Institute, but many other countries might be at the receiving end. And lastly, we don't know clearly yet on what basis the prices will be fixed. Okay, as I told you, there is an initiative called ACT Accelerator. Through the ACT Accelerator, many public funds have been routed for the development of these vaccines. Okay, then the production should ideally happen. Or the price should normally fixed plus cost of production plus some amount for the sustainable production. But we don't know that. These people people may even charge for the high profitability or market-based pricing mechanism. So that might be problematic. So these are some of the concerns related to the fair and equitable allocation of vaccine in WHO. The principles are there, but implementation is still creates confusion as well as concern from the perspective of fair and equitable access. So one more sentence, I'll stop it there. So many government leaders during the opening of World Health Assembly mentioned that the vaccine is a global public good. But if this is not the way to ensure that the vaccine is a global public good. So, but if you look at the WHO resolution, it never mentioned vaccine as a global public good. It just mentioned vaccination as a global public good, not the vaccine. So this is also a matter of concern. If it's a global public good, then there would be much more decentralized production, much more technology transfer. There would be many more actors. The price will really go down. So I am afraid that this may result in sort of further profiteering. Thank you.
Thank you, sir. Yeah, Priyanka, if you can conclude.
Yeah, I think Mr. Gopakumar has given a very good detailed answer, which covers everything. And like he said, accelerator, I think almost 165 countries are already in agreement and are supporting that. But things will unfold. I don't want, he knows this answer better and I don't want to repeat. But yes, vaccine for 7 billion people will not be available in one go. And like he said, countries who are manufacturing it, India, China, may be in a fortunate situation because we have a huge manufacturing capacity. But a lot of countries in Africa and the smaller countries may not have that capacity. But the world has to understand, the countries, even countries developing it, manufacturing it, and have the power to buy vaccines have to understand. How did the pandemic start? If China had full vaccination, obviously it would not transfer to Italy. So if we do not have vaccination for each and every person, the pandemic will keep coming back. And not just this one, it could be coming back with mutations, etc. So vaccination has to be made available to all eventually. But depending on, I think, need, the spread of the pandemic, and also covering the health workers first. Like I've been saying that we need to keep making our public health systems robust. I do have a call at 2 p.m. So I'm left with 2 minutes, and I wanted to thank Marwadi University and also Mr. Gopakumar. It was great to learn a lot from him as well. Thanks a lot, Professor Dave and Professor Omar.
Thank you. Professor Umar, if you can conclude and provide word of thanks quickly.
Yes, thank you. It was quite an experience to listen both of the esteemed speakers. As a student of international, I was just thinking that we keep on writing that this is the binding instrument in case of health regulations, in case of Paris agreements and all those things. But when it comes to enforceability, the only area which is enforced in all its spirit are the international trade rules. So I was just thinking, what can be the reason for this dichotomy? And yes, what is encouraging is the steps taken by the organizations like WHO in the form of COVAX, where countries have paid allegiance to the idea where equitable distribution of medicines and vaccinations would be done. But we really have to wait and watch how that interacts with other ideas, popular ideas of benefit sharing and technology transfer and IPRs and all those things. They have to be still explored. But I can thank with all warmth the exposition by Ms. Priyanka and Mr. Gopakumar, the way they have brought out and culled out the issues along with the basic framework of the international health law. And this is something which will give quite a perspective to the audience over here. And once we upload the video, I think people will be immensely benefiting from it. So on behalf of the Weera Center for Peace, Justice and International Law, and if Professor Dave may permit, on behalf of Marwadi University, I take this opportunity to thank both of the speakers from the bottom of our hearts, and we hope And we look forward to further interactions with you in due course of time. Thank you so much, Ms. Priyanka and Mr. Gopakumar. It was a pleasure.
Thank you, Priyanka. Thank you, Gopakumar. And thank you all the attendees who have attended this webinar. And I hope we will meet soon for some other such type of event. Thank you all.
Thank you very much. Thank you, Priyanka, too.
Thank you.
Thank you.